Good morning, everyone. Morning, colleagues. Thank you all so much for being here today. My name is Nyaradzo Pariola, and I'm an advocacy specialist here at the Center for the Study of Violence and Reconciliation. And it is my privilege to serve as your moderator today. We welcome you to our webinar where we hope to raise awareness and advocate for the rights of victims of torture, particularly the rights of human rights defenders who work on the front lines. We're doing this in observance of the International Day in support of victims of torture, which takes place on June 26th each year. We're a day early, but I think what matters is that we're here. This United Nations Sanction Day is a powerful reminder of our collective commitment to uphold the absolute prohibition of torture and to advocate for a world free from such inhumane practices. As we gather here today, we stand in solidarity with countless victims of torture, particularly those who bravely work on the front lines, our human rights defenders. Today, we'll address these pressing human rights issues and the urgent need for accountability, since unfortunately, many threats against human rights defenders go uninvestigated, leading to a culture of impunity that perpetuates harm and erodes civic engagement. We are privileged to have a distinguished panel of experts who will share their insights and experiences and help us to navigate these complex issues and identify actionable pathways forward. Our objectives today are clear. We aim to highlight the realities of torture, cruel, inhumane, and degrading treatment and their profound impacts on HRDs and how to address it. We'll discuss the threats HRDs face and their implications for the well-being of human rights defenders and civil society as well. We'll also explore how to popularize the protective measures and policies, particularly those envisioned by the Esperanza Protocol. I encourage all participants to engage actively in today's discussions and to share your insights and experiences. Together, we can forge a path towards the greater protection of human rights defenders and a stronger commitment to eradicating torture. Thank you so much for being here. Without much further ado, I am now going to allow us to start this very important conversation by welcoming our first speaker, our Executive Director, Ms. Anna Moyo. Before Anna speaks, actually, just to ask if you're posting this on your social media platforms, please don't forget to tag us at _CSVR. And also perhaps while the speakers are presenting, if you have questions already, we have a Q&A button at the bottom. Please already start typing your questions so we can get straight into the questions when our speakers finish. So our director will do the welcome remarks, and then the speakers will all speak one after the other until 11, and then we'll go into a time of Q&A. Anna, thank you so much for being here. Over to you.
Thank you. Thank you so much, Nyari, and good morning, everyone. I'm delighted to be in this panel, in this webinar commemorating the International Day in support of victims of torture, a day commemorated worldwide, basically to, amongst other things, highlight the plight of victims of torture, also share some of the experiences and the journey they have to undergo, some of their experiences, as well as what needs and rights need to be upheld to ensure that they also enjoy these rights. As we all know, particularly those organizations working with victims of torture, CSVR is one of them on the continent, that most victims of torture, who some of them become refugees, some become internally displaced persons. A lot of torture is experienced during conflict times, but there's also a lot of torture that happens even during peace times in more stable societies like South Africa, amongst others. It is usually government action, it is police action, but we see also a lot of torture being perpetrated by non-state actors, which all require all hands on deck in terms of addressing particularly the trauma attendant to having undergone an experience of torture on the one hand, on the other hand, also being an individual or a person who enjoys the rights, be it in a host country, in a country of origin, in a refugee camp, in an IDP camp, or wherever victims of torture find themselves. We also know the toll that the victims of trauma, particularly indirect victims such as family members and those who support direct victims, undergo, particularly in supporting direct victims of torture within family settings, within community setting, and this support, the support that needs to be extended to them as well, particularly given the indirect trauma that they also experience as a result of the direct trauma faced by direct victims. Again, it's a call for all hands on deck in supporting victims, understanding their experiences, understanding their needs, as well as being in a position to support them, to provide the support and the services that they need in order to restore their dignity, restore again their rights, as well as ensure that their functioning and well-being in communities, in society, and in many other spaces where they are required to show up is restored. Without much further ado, I welcome all of us to this meeting to share some of these experiences, to share from the practitioner perspectives. Sumaiya is here around some of the experiences of victims of torture, to share as well from the legal services perspective and human rights perspective. Martin is here to share some of those experiences and ensure that as a collective, we provide holistic services and adopt multidisciplinary approaches to addressing the plight of victims of torture on the continent and beyond. So as part of this commemoration, we really want to shine the spotlight on some of these experiences and make a concerted call for collective action towards ensuring that victims of torture are not only supported, but that their well-being is prioritized wherever they find themselves. We want to make a call, even today through this meeting, through this webinar, to say that we see you, we support you, and we are here for you. And we want to also ensure that wherever they are and whatever experiences they've gone through, that their dignity, their well-being, as well as their wellness remains a priority for organizations like us who continuously provide services to victims of torture in all their diversity, as IDPs, as refugees, as migrants, as people within the countries where torture has taken place, as people within communities where torture has taken place, but as people who have been experienced this torture and its impacts on their lives and in the lives of those around them. Thank you.
Thank you so much, Anna, for that very strong solidarity message in support of all human rights defenders or activists, social justice activists. Thank you so much. We'll now move to our panelists. Our first speaker is supposed to be Sumaiya, but it looks like she might have just dropped off. Connectivity is a hazard these days. Okay, I think while we wait for Sumaiya, I will move on to our next speaker, Ms. Constance Makarati, who will be speaking on resilience in the face of adversity and on the work of the Women Human Rights Defenders Initiatives. Constance Makarati is the co-founder and co-weaver of the African Initiative of Women Human Rights Defenders Initiative, where she's co-leading transformative support for women human rights defenders and driving bold action by leading high-impact social ventures for sustainable change. Constance, thank you so much for being here with us today. Please, we look forward to hearing from you. Please go ahead.
Good morning, Nyaradzo, and thank you so much for this platform, and thank you to all who have joined this important webinar. Today, I speak to you today as one of women human rights defenders across Africa who has held the line through fire, backlash, and isolation. And on this day, which is International Day in support of victims of torture, I want to honor all the women human rights defenders who have faced unimaginable horrors at the hands of state actors and non-state actors. But today, I wish to expand our imagination of what torture looks like and who its victims are. For women human rights defenders, torture is physical as well as it is systematic. It is the rape used to silence land activists or peace builders in war-torn conflict areas. It is the forced exile of a queer defender. It is the cyber surveillance of a feminist whistleblower. It is the public shaming, blacklisting, gaslighting, and legal harassment faced by women who dare to defend others. These are gendered forms of torture that remain unacknowledged by many states and even the human rights ecosystem. As Nyaradzo introduced, the Women Human Rights Defenders Initiative is a transnational WHRD-led care meshwork working to safeguard women defenders across Africa and beyond. We do this by weaving physical, digital, emotional, and strategic sanctuaries because safety is a condition for activism to thrive. And we center this through 5 threads. 1, which is safety and safeguarding. 2, well-being and livelihoods. 3, capacity enhancement. 4, continuity of activism. And 5, care is the connective tissue. And why we've put all these threads together is because we are weaving a mesh that will safeguard us, our rights, our minds, our bodies in a way that we wished existed before any form of torture or inhumane treatment happened. And we are weaving this through women defenders who have lived this experience, some of whom have been incarcerated and faced unimaginable horrors. And when we look at torture, it's usually from a system where we are being tortured for what we do and for who we are. And it's usually women or queer women or poor women or indigenous women or refugees or those who dare to be visible and speak up against, those who are emanating these injustices. And for us, torture against women human rights defenders is both public and invisible, and it's often the invisible torture that remains unaddressed. It happens in prisons. It also happens in online spaces. It also happens through smear campaigns, denial of bail, threats to our children, refusal of medical treatment while in detention. And it's always a situation where we are told to be grateful that we survived. And instead of being supported to recover or to rebuild or to reclaim, we are put in the situation where we are celebrated for being resilient. But what is this resilience and what does it look like? And how do we bounce back from such a terrible ordeal or traumatic ordeal or event that happens when we are in these sort of situations? We also need to center women human rights defenders not just as survivors, but as the remakers of these systems, because only through experience can we actually forge systems that actually work when for women human rights defenders at risk. We also need not just shelters or relocations or temporary protection. We need a strategy that transforms the situation soon as it happens. And I know the ecosystem, when we talk about protection mechanisms. We are always talking about we need long-term support. And is it long-term? What does long-term look like? Is it 1 year, 2 years after the threat or the risk? Or is it can be short-term but transformative from the very word go? Because we've noticed a situation where once women human rights defenders are supported even for up to a year, already the ecosystem becomes tired to support that woman. Is because we've been also treating them as charity cases and not supporting their livelihood or making them, fully equipped to carry on or continue with their activism on their own terms. And it's stemming from a situation where we've also created some sort of dependency on protection mechanisms. And we've seen how the backlash when women are standing up or protesting for their rights, the rhetoric out there is these people are cash fists or they are singing for their supper, and yet they are actually, defending the rights that are supposed to be rights for all. And at the WHRD Initiative, we feel we need to weave a truly feminist infrastructure that is sustainable. And this happens through pushing back on all forms of violence and torture, which emanates from a digital perspective, physical perspective, emotional perspective. So we also need to respond in that similar way as well, but creating sustainable conditions for women human rights defenders to continue their work. So today I really call for torture against women human rights defenders to be named, and it must be recognized, it must be redressed, and it must be prevented. We've seen numerous women human rights defenders, intergenerational women human rights defenders being incarcerated for speaking up and being tortured, being physically abused. And it has also taken a form of transnational repression. We've seen it in Tanzania, we've seen it in Uganda, we've also seen it in Zimbabwe. And we need to really raise the cost of these perpetrators to be brought to book. And that is where we actually need to focus on. How do we bring these people who are being protected by the states and who come with masks? How are we going to push back on these sort of actors? And I think I will just stand here for now. Thank you so much, Nyaradzo.
Wow. Thank you so much, Constance, for painting such a clear picture of the horrors that women defenders in particular face. It's a sobering reality. I think that highlights the importance of this work of protection. Thank you for the work that you are doing to push back on these horrors, and just for highlighting the critical importance of support for defenders as they recover from their traumatic ordeals, particularly the importance of long-term support. And I like what you said, this torture that's happening, this treatment, let's name it, let's recognize it, let's redress it, and most importantly, let's prevent it. We need to prevent it and raise the cost of impunity. Thank you. Thank you so much for your intervention. I'll now ask Sumaiya Mohamed, who's a mental health and psychosocial support specialist, a mental health specialist here at CSVR, to please take the floor. Thank you, Sumaiya.
Thank you. Thank you so much, Nyari. And once again, thank you to Constance. A very, we hear the narratives. And I think the sadness around these narratives is that they are not new stories, right? The narratives around torture, cruel, inhumane, and degrading treatment, and the persecution of human rights defenders has a long history. It has a painful history across Africa and globally. As I'm speaking, names like Steve Biko still, comes to mind, icons of resistance who lost their lives in acts of torture and violence. And tragically, the list continues to grow, right? Thulani Maseko comes to mind, a brilliant lawyer, a committed activist, a life, unjustly taken. So we see that over the years, and Constance spoke about even kind of this intergenerational women rights defenders. But we see this kind of, the story hasn't changed, the names have. And that's a problem in and of itself. So despite international prohibitions, torture and CIDT continue to be used by both state and non-state actors, and standing at the front lines of this violence are human rights defenders, men and women who step in when states fail, when people are denied justice, dignity, and basic rights. In many countries, HRDs are not protected. They are targeted in doing their work of social justice, whether that be defending the right to clean water, health, land, speech, and freedom from torture. They become the enemies of those in power, such as governments, corporations, and even criminal networks. We know that the environments in which HRDs operate has become more dangerous and more restrictive, and this danger is not theoretical. It's not just a story, it's lived experience, and it's experiences that come to our door more and more in the past few years. In CSVR, we recently worked with a group of HRDs from the Southern Africa region. Our work is focused on providing mental health and psychosocial support to HRDs who have experienced torture and CIDT. What we found within this group is they shared their experiences of torture and CIDT, and it's this kind of, you hear a number of narratives that speaks to violence, that speaks to trauma, that extends beyond the individual. It impacts their family, it impacts their work life, it impacts their social spaces, and it impacts in how they position themselves within their worlds. The acts that they spoke about included sexual harassment and intimidation, cyberbullying and hacking, being unlawfully detained, vandalism of property, death threats, threats to safety, their names and reputations being attacked, and subject to physical violence and psychological warfare. We know that this is not just a security issue, it's a health issue, it's a human issue. The threats they face don't end when headlines fade and we stop seeing it online. These impacts go beyond. Particularly what we've noted in our work is that the psychological scars last long after. HRDs reflected experiencing emotional numbing, emotional burnout and exhaustion, confusion and isolation, struggling with family breakdowns, chronic anxiety and physical pain. Mental health challenges included depression, post-traumatic stress, and in some cases, suicidal thoughts. The loss of hope and the lost sense of future, with frustration around political systems and structures, and high levels of mistrust. Some are forced into exile, others self-censor just to stay safe. Many are unable to find work due to discrimination linked to their activism. And here's the impact, right? Civil society is shrinking and we're losing activists, we're losing voices, we're losing brave people from the social justice movement. Our civil society is being threatened. We know that threats are not just words, they are violations in themselves. They breach the rights to security, dignity, and freedom, and they violate the right to be free from torture, the right to express, to associate, to move freely, and to defend rights. How we respond to this is important. We need to respond with urgency and with care, not only because it's morally right, but because without HRDs, civil society collapses, progress dies. Based on our work with HRDs over the past years, learnings and insights that have guided the key recommendations we would like to put forward today, and echoing as well what Constance was speaking about, is firstly, we must advocate for comprehensive rehabilitation services that includes legal, medical, psychosocial, and social reintegration. And how we think about that in not creating the charity cases and the dependency, but how do we empower? How do we create sustainability and self-sufficiency within the system? Second, we must demand and defend the right to justice, redress, and reparations for HRDs who have suffered violations. Thirdly, we need to build trauma-informed organizations. Our social justice spaces need to understand the psychological and physical toll of this work and actively build in strategies to support the people doing it. We need to strengthen networks of solidarity and resilience, so HRDs need to know they're not alone, that there are others who will stand with them, amplify their voice, and hold space for healing. Finally, we must stop treating psychosocial support as optional. Mental health is not a luxury. It is essential to the sustainability of human rights work. If we want to protect civil society, we must protect those who protect it in all ways. Let's not just remember the names of those we've lost, such as Steve Biko, Tulani Maseko, and countless others, but let's fight to ensure the next generation of HRDs doesn't face the same fate. Thank you. Nyari, over to you.
Oh, thank you so much, Sumaiya, for that intervention and really building upon what Constance had, with the conversation that Constance had started already for us. I think what is so sad is what you say, that tragically, these are not new stories. It's just the names that have changed. The story remains the same. And that just means something needs to change. Thank you also for highlighting the all-encompassing impact of this violence, particularly the psychological impact, and the sad reality that what we lose, we're losing the voices of those that are pushing for the human rights of everybody, and that without human rights defenders, social justice activists, progress suffers, progress dies. So it really just highlights the importance of looking out for human rights defenders. And also thank you for this very important point about how we create sustainability and self-sufficiency by recognizing that mental health is not a luxury, that we have to create trauma-informed organizations. I really hope, colleagues, that we can take that away with us and ensure that we build in strategies in our organizations to support the work that our HRDs and social justice activists are doing. Thank you so much for that intervention. I'm now going to ask Mr. Edward Mbanya, a victims advocate from Amnesty International, to take the floor. He is currently the Civil Liberties Campaigns Manager at Amnesty International Kenya. He is a holder of an LLB degree from the University of Nairobi and an advocate of the High Court of Kenya with 18 years of experience in litigation. He has specialized in police abuse of power cases since 2015 and practiced as a victims advocate in International Justice Mission Kenya and Amnesty International, having won several landmark cases, including the sentencing to death of the most senior police commander to date. Wow, Edward, please, you may take the floor. Thank you.
Thank you, Nyari. Just a disclaimer, I'm actually talking to you from Nairobi. So should my network be sketchy, just let me know. I'll figure out how to go around it. Yeah, and thank you, Sumaiya. You've actually got us on a good footing. You've made us understand the impact on HRDs in terms of the work that they do. And my work is not as much as simple, but it's basically just to set out some solutions that are out there that we can capitalize on. I think I'll share something right now. I'm hoping that I can share a PowerPoint presentation. I don't know if that's possible. I've just sent a request.
Sure, Google, if you can please help us. Edward, if you go to the share button, does it allow you? Is it allowing you?
Yes, it has. It has agreed.
Okay, great. Please go ahead and share.
Okay, I hope you can see my screen.
Yes, we can. Thank you.
Okay, that is good.
Are you able to make it into a slideshow?
Yeah, I'm trying to do that.
At the bottom, right at the bottom on your right-hand side.
Thanks, Kuba.
Where it says right at the bottom, I think it's the second icon next to the Zoom. Not that one, not the book one. Next to the book on the right-hand side. That one.
Okay, thank you. Okay, so thank you for the introduction. I'll get right to it, given that time is not on my side, and have 15 minutes to summarize a very well done document, about 80 pages long. So I'll just basically dwell on the highlights. And the first thing I'd like to take our attention to is, what is the Esperanza Protocol? I'm hoping that most of you know that the Esperanza Protocol is an international tool that provides guidelines and a roadmap for effectively addressing threats against HRDs. It promotes effective response to threats by guiding states on investigation, prosecution, and punishment of perpetrators. It emphasizes the need to understand threats as a human rights issue that often goes unpunished. Now, the most important take-home I want you to see is that the Esperanza Protocol doesn't have legal force. What it does is offers a framework for developing policies in nations. Unlike other protocols, we have some which have legal binding force because they are part of conventions or treaties that have been signed by states. But for the Esperanza Protocol, it basically doesn't have legal force. It has been inspired by similar international instruments, such as the Manual on Effective Investigation and Documentation of Torture and other cruel, inhuman, or degrading treatment or punishment, what we usually call the Istanbul Protocol. It has also been inspired by the Minnesota Protocol on Investigation of Potentially Unlawful Death and the Latin America Model Protocol for Investigation of Death of Women from Gender-Based Violence. Ideally, these tools have formed the basis for the Esperanza Protocol, and it has been designed such that it works hand in hand with these protocols. Some of these protocols have already been signed in by states, so they are obligatory in some of the states. So why the name Esperanza? That was the first question I asked myself. It is the name of a town where a human rights defender, Bata Caceres, was born and she died. Esperanza means hope in Spanish and expresses the desire to inspire change and reflect the possibilities of social transformation and justice that HRDs pursue. Esperanza, the town, La Esperanza, is a town in Honduras. And Bata Caceres was a HRD who had valiantly led protests against the construction of a dam on an ecologically sensitive part of a river. And this dam was a state-sanctioned project. And she started experiencing a lot of threats from people she believed to be under the employment of the company that had received the contract from the state. She also received threats from state officers and state politicians. With time, attacks followed. But despite her many reports about these threats and attacks, nothing was done. Eventually, a year after she had received an international award, someone came to her home in the middle of the night and killed her. This person was hooded and masked. And to date, it's still not known who killed Bata. So this is why the Esperanza Protocol was envisioned to actually capture the issues facing HRDs. So the protocol gives us a working definition of the human rights defender. And it says anyone who individually or in association with others promotes or protects the realization of human rights and fundamental freedoms, either at the national or international levels. Now, this particular definition is not based on profession or identity of an individual or the collective or on the actions, but it is basically based. It is based on the functions of what they do. It's the same definition found in the Declaration on Human Rights Defenders. And for me, this is important because in the past, we had always tried to define HRD based on what they do. And under some of those particular definitions, a person like a lawyer would not be considered a HRD. Threats. Sumaiya has talked about threats, and then the protocol gives a particular working definition. It says that a threat is an intentional conduct that indicates future harm or that intimidates a HRD, their family, or community. They include collective, directive, and indirect, explicit, and symbolic threats, whether in offline or online spaces. You can see that particular definition of a threat is quite encompassing. It must be a future harm. It affects the HRD and also their family or their community. It talks about even symbolic threats, which may not necessarily have a harm on a person. So historically and globally, threats have been used to intimidate HRDs and their families, their allies. It causes them to limit, change, or cease their activities, disrupt their daily lives. It stigmatizes human rights defenders. It endangers them. It causes them to have a chilling effect on other HRDs and have a long-lasting, lifelong impact on HRDs. This is more so especially where there is death accompanying the threats. And the purpose is basically to frustrate the work that HRDs are doing. And most often you'll find that the threats are accompanied by assault, accompanied with torture, there's kidnapping, there's enforced disappearances. We find this forced displacement of people who are fighting for land rights. And finally, you also have the killings. Without the active work of people who stand for their rights and the rights of others, a society would lose a critical force for the effective guarantee of rights and democracy and the rule of law. However, despite the seriousness of these threats, it seems these crimes remain unpunished in most jurisdictions and perpetrators remain unidentified, as was seen in the case of Bata. The impunity enables additional harm and fuels cycles of violence. When states do act, their action is primarily or exclusively focused on physical security protection measures. These include bodyguards, emergency mobile phones. While this is important, it does not affect the factors, it does not address the factors that generate the risk that the HRDs are facing, the emotional, the psychological, the social, and financial impacts that are occasioned on HRDs and their families as a result of these threats. The protocol encompasses states' international legal obligations to guarantee the right to defend human rights, the focus of guidelines for public policies. And this protocol is very progressive because it even includes surveillance, criminalization, judicial harassment, what we know as lap suits, and has included this as part of the protocol, only to the extent that they meet the definition of threats and pose a serious risk to the HRDs. What are these international legal obligations that are imposed on states? The first one is due to the serious moral and psychological impact threats have on recipients, they may qualify as torture or cruel, inhuman, or degrading treatment under international law. That is how serious this protocol has treated the psychological impact that Sumaiya was talking about that threats have on HRDs. When threats interfere with HRDs' ability to access international human rights bodies or discourage, retaliate, or punish the participation of corporations with these bodies, they may constitute reprisals. So basically, if a threat is interfering with the right of a HRD to access an international human rights body, it is classified as a reprisal under international human rights law. The second is the international obligation to respect and guarantee rights. States are obligated to refrain from interfering with the exercise of human rights defenders' rights, and in particular, they must refrain from undue restrictions that limit the work of human rights defenders, and including harassments and killings and criminalization. The protocol makes states liable for human rights violations committed by either state or non-state actors. So it's not just a state who is obligated in terms of obligations to respect and guarantee rights of human rights defenders, but also non-state actors. It classifies responsibility into two. The direct responsibility, which may be incurred when a violation is committed by a state actor, or an actor with state support collaboration, or the acquiescence or tolerance by the state, including a perversive action. So an omission by the state not to protect a right is basically an acquiescence. So that now falls as direct responsibility, which may be actionable on the state, according to the protocol. The second is indirect responsibility, which may be incurred when violation is incurred by a non-state actor, or when the state fails to act with due diligence to prevent the violation. Or alternatively, which has been common in some of these African countries, when the state fails to investigate and punish those responsible for the threat or action against the human rights defender. The obligation to prevent, investigate, and punish violations and provide reparations to victims are applicable to acts committed by both states and non-state actors. Where a state is responsible for human rights violations directly or indirectly, it is obligated to provide redress. So the protocol provides standards of due diligence to enable us to know when a state is liable or not liable for actions or omissions. So states have a general due diligence obligation to ensure that they have designed and operated guarantees and ensure that the rights of all people, including HRDs, are protected. Then a specific due diligence obligation exists where a state should know or should have known of a particular risk of harm to a person or an identifiable group like the human rights defenders. Then we have the reinforced due diligence obligation, which exists in relation to groups subject to particular risks based on the identity, situation, or role in a society, e.g. women, human rights defenders. And this class faces additional risks that are gendered and intersectional and are shaped by stereotypes. We have learned human rights defenders, indigenous human rights defenders, and trade union members and leaders, journalists, lawyers, etc. So states under the due diligence obligation have to act when they have actual knowledge of a threat or have identified a pattern of threats towards a specific group or community to the HRD. The knowledge of this threat is not limited to a formal criminal complaint, and this is progressive. Other indicators of risks that make violence foreseeable should be considered. These are systemic risks, the presence of armed actors, organization of crimes, or high levels of impunity related to past threats. In Kenya, in the past 1 week, we've had an interesting development where protesters going on the streets are now no longer being attacked by police, but actually being attacked by civilians who are armed, and they seem to be hired by the state. So this is what the protocol is talking about, that if such risks are foreseeable, then there's a specific due diligence obligation on the state to ensure that these threats do not harm HRDs. And the protocol states that state agents should take reasonable action to prevent such risks when aware of such real and imminent danger. There's the obligation to ensure equality and non-discrimination, which I think is quite explanatory. We have the obligation to provide redress for threats against HRDs. I want to touch on this quite a bit, because we cannot have justice if you do not have redress for harm occasioned on human rights defenders. And this obligation provides that states must provide reparations for human rights violated by threats. Reparations and international law are intended to fully restore rights to the extent possible, to repair the harm caused and avoid repetition. In the event of ongoing violation, the immediate obligation should be focused on cessation of that particular violation. Reparations must be given for harm suffered as a result of the human rights violation and must be proportional to the damage caused and the gravity of the violation. So the reparation cannot be a token amount. It must be proportional to the harm and damage suffered by the HRD. Patterns of violence and discrimination, as well as state policies and practices that enable the violation against the HRDs, must be taken into account in computing these reparations. The reparations may be given or awarded to individuals or collective groups depending on the situation that is at hand. Under international law, reparations may include restitution, rehabilitation, certification, satisfaction, guarantees of non-repetition, and compensation. These measures can be interrelated and complementary, meaning it's possible to have all these remedies being given under reparations at the same time. Now, the objective of reparations is to restore the enjoyment of rights vested that were violated. In relation to threats, restitution measures include measures to enable the HRD displaced due to the threats to return to the residents and safely, in a safe manner and voluntarily. Rehabilitation seeks to redress the harm to the physical, mental, and psychological integrity, and to restore the victim's dignity. Then we have satisfaction, which seeks to repair harm by establishing and sharing the truth about violations, restoring the dignity of those affected, and pursuing accountability for the perpetrators. So this is also looking outward to the society. That is what satisfaction deals with. It is linked to obligation to clarify past violations, which would include measures to develop symbolic reparations and make the role of HRDs in a democratic society more visible. Then we have the guarantee of non-repetition, which is to avoid recurrence of the violation that took place. So it's not just enough to give reparations. The state is also obligated to make sure that the violation does not happen or repeat again. I repeat, monetary compensation must be given to HRD victims of threats to repair harm suffered effectively and to the fullest extent possible. That is what is recommended by the protocol, which is also quite monumental, because many a time you have states giving reparations, but they don't give monetary compensation. And the monetary compensation should include legal fees and costs of litigation in national and international courts. The final bit I wanted us to look at was on the role of corporations and other business enterprises. These are usually the non-state actors. The protocol provides that corporations and other business enterprises are sources of risks for human rights defenders. Human rights defenders can be victims of threats because they expose harmful business conduct, often in collaboration with state, that adversely impact the rights of communities, including environmental rights. Corporations are most commonly involved in threats and attacks of HRDs and include corporations involved in extractive industries, in protection services, and surveillance technology companies. Now, the protocol provides that states are responsible for regulating and responding to human rights violations attributable to corporations and other business enterprises. Businesses have a responsibility to refrain from infringing on human rights of HRDs, including threats and attacks against them. You remember we started off with the story of butter. You can see now the protocol has been developed and it is now taking care of an instance of what happened to her. Corporations must ensure their activities, actions, and omissions do not lead to threats against HRDs. The other aspects of corporations or businesses is technology companies. They are required to refrain from designing, developing, producing, and selling technology to both private and government actors that is weaponized to inhibit the defense of human rights. So in Kenya, we've had a scenario where we have the mobile phone company, which is the dominant company, which has been used to help track human rights defenders by the authorities. And these people have been abducted. Some of them end up being found tortured, others found dead. So that's what this particular protocol is talking about. And the final issue I wanted to highlight in the protocol is a general obligation to create an environment to defend rights on the state. This is a general due diligence obligation. And the protocol provides that states must allocate an adequate budget to fund public policies aimed at guaranteeing a safe and enabling environment. The existence of norms and institutions alone is insufficient. They must have the necessary resources to be effective. Of course, in Africa, some states face unique challenges in addressing underlying violence against human rights defenders, which may include lack of political will, state capture or participation in crime, shrinking spaces in the civic space, impunity from threats and attacks on human rights defenders, and overemphasis on protection mechanisms for HRDs or hard security measures. Now, these obstacles, while very real, should not be interpreted to relieve that they relieve the state from full compliance with its obligations under international law. They can be used to inform policy design and in the implementation and evaluation of policy. So that is the end of my presentation, given the short limited time I had been given. I'm hoping I've done some justice to what I have done. It's really impossible to do justice to such a well-crafted document that is about 87 pages long. But I'm hoping that I have shed some light on what the Esperanza protocol is and what it basically provides in terms of obligations to states and reliefs to HRDs. Thank you.
Thank you so much, Edward. You absolutely have done it justice in the very short time that you had. Thank you so much for highlighting, solutions that we can actually capitalize on to address this important issue and spotlighting the Esperanza protocol for us. Thank you really for fleshing out the all-encompassing definitions of the protocol. For example, the examples that you gave, who's an HRD, what constitutes a threat, just how broad those are. And that hopefully, this should lead to greater protections if properly implemented, of course. In this regard, I also want to thank you for highlighting so clearly the human rights, legal and moral obligations that states carry and their responsibility to act and protect HRDs in terms of not just this policy framework, but all the other ones that you mentioned as well. And, one central theme that seems to be coming through all the interventions is this issue that, if we don't push this agenda for protecting social justice activists, human rights defenders, we lose a critical force for the effective guarantee of human rights and democracy. So thank you so much for that, for your intervention. I'm now going to ask our last speaker, Mr. Martin Mavenjina, to also make his intervention. Martin is a constitutional and human rights lawyer with extensive experience in research, policy review, and advocacy on civic space, security governance, counterterrorism, and transitional justice at national, regional, and international levels. He is currently employed at the Kenya Human Rights Commission as a senior program advisor, transitional justice. His engagements with other peer review mechanisms like the United Nations Human Rights Council, the African Commission on Human and People's Rights, and the Assembly of State Parties have culminated in numerous positive resolutions for victims of human rights violations. Martin is going to now take us through how we as civil society can utilize this Esperanza protocol that we've just learned about to further the protection of human rights defenders and social justice activists in our regions. Thank you, Martin. Over to you.
Thank you, Matt. Thank you, Nyari. Good morning, good afternoon. Allow me first and foremost to thank CSVR and the other partners for having me here to make this presentation on how CSOs can utilize or make good use of the Esperanza protocol. Let me start first and foremost by thanking the previous speakers for their excellent presentation. So as I dive into my presentation, allow me to begin by starting with the historical context. Historical and global threats have been used to intimidate human rights defenders, their families, their communities, and are directed to inhabiting individuals and collective actions. Before I go, Nyari, let me just put a rider. I don't have a PowerPoint presentation. And in the event that my internet gets off, there are two possibilities. It's certainly not that I have a poor connection. There are protests today, so there is a possibility that the state could actually tamper with the internet. But let me delve back into the discussion and into the presentation. So threats not only hinder the important work carried out by human rights defenders, but also disrupt their daily lives and those of their families, communities, and allies, and endanger them and have a chilling effect on human rights defenders. So when you look at, so in the context of Africa or globally, human rights defenders in different parts of the world continue to be subjected to serious threats, primarily from repressive policies or legislation or violent response by security agencies. Many governments within Africa and other parts of the world are yet to create an enabling environment that would ensure that human rights defenders are able to not only enjoy their constitutional rights, but also, be able to fight for the rights of others. Many human rights, it's against that background that many human rights defenders, not only in Africa, but also around different parts of the world, have been subjected to serious human rights violations that include, amongst others, torture, unlawful arrests, detentions, and in some extreme circumstances have resulted to death. So so the relevance of the Esperanza Protocol to civil society organizations in Africa are the following. Firstly, the protocol provides guidelines based on international human rights law directed primarily to government and justice officials to promote adequate response to threats against human rights defenders and support the effective investigation, prosecution, and punishment of these threats. As such, this will be this is an important resource or guideline for civil society organizations in Africa and other parts of the world that they can use to ensure that relevant state agencies, like the different investigative agencies, are able to actually effectively carry out their work, or the different prosecutorial agencies are able to actually follow up on holding perpetrators to account. The second relevance is the protocol is a global tool that includes international human rights international human rights law considerations that should be taken into account when responding to threats against human rights defenders, including key aspects of legal analysis to threats, public and criminal policy considerations, and the evaluation of due diligence in investigation, prosecution, and punishment. As such, the protocol therefore would be useful for human rights defenders to engage with relevant state actors. The third relevancy of this protocol to CSOs in Africa is that it promotes an adequate response to threats against human rights defenders, including influencing public policy guidelines and guidelines to diligent criminal investigation. As you may be aware, many countries in Africa usually grapple with this whole issue of investigations. In fact, in my honest opinion, I think when you look at investigations, I always say investigations are akin to the Bermuda Triangle, because when human rights defenders are violated or in extreme circumstances are subjected to death, you are told by investigative authorities that, we are still investigating. I mean, if you look at the Kenyan context, it took us 5 years to actually hold the perpetrators of Willy Kimani, a human rights lawyer, to account. And the other cases of unlawful death that are still, being investigated. So this protocol actually gives a guideline that civil society organizations can use to engage relevant actors on how to ensure that investigations are swift, effective, and do not take an indeterminate period of time. The fourth relevance is around how CSOs can use the protocol, how CSOs can use a protocol to ensure that states actually adhere to certain policy or international obligations that they may be as signatories to. As you're aware, many states in Africa usually have a semblance of legal, or should I say legal frameworks, or a semblance of legal frameworks that provide for investigations and accountability. So this protocol can actually be used by our civil society practitioners to not only re-emphasize why states need to ensure that the effective investigation and prosecution is conducted, but also as to why perpetrators of serious human rights violations should be held to account. So it can be used as a tool to actually specifically engage our lawmakers on why it's not only enough to actually enact legislation or have progressive pieces of legislation, but how do we breathe life to these actual provisions of the law. The fifth relevance of the protocol is that when you look at the protocols per se, the Esperanza Protocol aims to form part of already existing. Basically, it gives legal effect, or it gives it aims to form part of such or form part of already comprehensive strategy via its guidelines for effectively responding to threats, which may be crucial to all of us attending this webinar. So it's an important tool that can be used to actually by civil society actors, not only to engage relevant policy actors, but also to train the different human rights networks or grassroots organizations that we work with, or even victims, to just know, when they're violated, what basically to know their rights. How do they go about having ensuring that the state is able to be hold this end of the bargain. It is recommended that the protocol does recommend that states revise their norms and practices to identify potential improvements, taking into consideration the guidance provided by the protocol. But as you may all be aware, this is not the case in most African states, whereby we do have a semblance of legislation, but in most instances, states are either not willing or to hold perpetrators to account, or not even willing to implement existing pieces of legislation. I think the key point I have to emphasize here is that broadly, there is a general lack of political will across different parts of the world. This protocol actually can be used by civil society organizations to actually change the narrative, because there seems to the biggest violators of human rights are usually those which are tasked with authority in different governments. So maybe in my honest thinking, this protocol can be used by civil society organizations to actually influence and change that perception and narrative, and actually get political buy-in, or to ensure that perpetrators of serious human rights violations are held to account. The other thing I must mention about the protocol is that its positive obligations that also include taking appropriate measure and exercising due diligence to prevent, investigate, prosecute, and punish violations, just come in to re-emphasize what obligation or what duties is placed on different actors within the government. If you remember, if you remember, every time I think after a certain period of time, in different parts of the world, we do hold elections. We do elect leaders who actually appoint different people to provide, to lead or to provide different expertise within government. So it is an obligation placed on them to actually ensure that we hold them to account, specifically those tasked with ensuring that all of us are able to enjoy our fundamental rights and freedom. So with that, I think I'll hand it back to you, Nyari. Thank you. I wish we would have more time, to delve further, but I think in the interest of time, I'll hand it back to you. Thank you, Nyari.
No, thank you so much, Martin, for that intervention and really highlighting, I think, two critical roles that we play as civil society, one being advocacy with our governments and the other being awareness raising with our networks, our communities, and others, social justice activists in our context. And I think, this is always the issue, isn't it? That even though we have this great international, in terms of human rights, international legal framework that even perhaps our governments have signed up to, it's always about, we always need to push for them to firstly sign up to the legal framework, but once they do, to ensure that they actually enact legislation to give effect to those obligations that they'll have signed up to. And once they have put the legislation in place, to ensure that there's a policy or regulations that actually, state how this legislation will be implemented. And I think for most of us, the policy frameworks are there, but it's how now do you implement? And thank you for just taking us through that it's great to have this, but it's meaningless if it's not actually acceded to, but also if there's no legislation to give effect to it. And that our role is now to push for our governments to implement these obligations, particularly with regards to human rights defenders. And I think even perhaps to partner with them to help, as you were saying, to approach the policy actors, to approach the investigative departments, the relevant state actors, with this knowledge. These are your actual obligations, and this is what it needs to look like in practice, and also just raising awareness with our constituencies on, this is our policy framework, this is what it says and how it's supposed to work. Let's encourage the relevant state actors in our regions to adhere to and to fulfill these obligations. So thank you so much for that. Well, colleagues, that brings us to the end of our panel intervention. I'm now going to open up for questions, comments, feedback. Let's have this conversation. As you've seen, it's a very timely conversation. These are clear and present dangers, threats, violence that's happening as we speak. What does it look like in your context, in your region? How can we take the protection of HRDs forward, perhaps just from some of your best practices that you may have? So you can either raise your hand and we'll ask you to speak, or you can put your question in the Q&A box, if you like. That's at the bottom of your screen. Sumaiya, please.
Hi, Nyari. Just one of the things that I wanted to add is around raising awareness about the Esperanza Protocol. So having worked with a number of HRDs and particularly young HRDs in the past 2 years, and seeing the impact of the work on them and how, wanting to, participate, be present, create change, but seeing the lack of support when things, kind of are going in a certain direction, threats, the detainment and so forth, and wanting to kind of run the other way because feeling, I'm passionate about my work and I'm passionate about what I'm advocating for, but this is a threat. This is a live threat. This is a threat to my family, and just that psychosocial impact in a sense. And when I heard about the Esperanza Protocol, I was like, why is this not more publicized? Why is this not out there? And so my thought is around how do we think about that in terms of raising awareness and popularizing it. Another aspect I know, in hosting webinars such as these, we find that a lot of HRDs do not attend, and that's for their own security and safety, the digital stuff, right? Around being safe. And so thinking around this webinar being on social media platforms, because it's their way of accessing information in a safer way for them than kind of being present in the space. And we see that a lot when we host webinars. We either have to have closed webinars with a particular group of people, or looking at how do we just get information out there. But this is important information. The conversation from Edward and Martin, sharing
with us and giving that breakdown of a very complex document. As Edward said, this is how many pages, and who's going to read that, and how do we create ways in which this information can be disseminated and absorbed, quick and easy. So yeah, just the publicizing and popularizing of the Esperanza Protocol. Thank you.
No, thank you so much for that, Sumaiya. And I'm glad that our communication team is here. So hopefully they're listening as well, and we can really disseminate this widely on our social media platforms. But I think what I'll undertake to do is to do fact sheets on the Esperanza Protocol that we can also disseminate widely. Thank you for that. I think absolutely critical. Any other comments? Perhaps questions for our panelists? Okay, and I think in the absence of any questions or comments, I'm going to ask Sumaiya to give us the closing remarks, please.
Thanks, Nyari. I'll be brief. We have a power outage, so someone's generator is really loud on my side. So I do apologize. I think just a few thoughts. One is there is, like I said, just definitely a need for us to raise awareness around what support structures look like, whether they be legal, whether they be medical, and so forth, and to work together to build that network of support. How do we connect with each other across, different regions, to build, kind of a community, in a sense, that can help and support HRDs to access support. One of the things that was spoken about is how threats in itself impact on the ability to access support. And so how do we kind of hold that thread to say that there are spaces that are available to access support? And then again, thinking about the sustainability, the self-sufficiency as well, whilst looking at what those structures look like. Another element for me is just across speakers, the conversation around, it isn't just one event happens, it's the ripple that comes with the long-term impact and the need for long-term support. The conversations around the psychosocial impact, it's the psychological impact and beyond. Communities are affected when an HRD is threatened. Families are affected when an HRD is threatened. And so we see kind of once again, the ripple that happens, and how do we come in, how do we provide support? Civil society is, kind of at a space we've got shrinking in terms of funding that's happening. The ability to do more is being, lots of red tape. And if we lose our HRDs, kind of what does that mean for us? What does that mean for civil society when they are the core of the work that we all do? And so, yeah, just kind of wanting to leave on that note, how do we defend the defenders, protect the defenders in a sense, and how do we do that collectively, not individually? Thanks, Nyari. Thanks, everyone.
Thank you so much, Sumaiya. Thank you for those words. Colleagues, I just want to take this opportunity to thank all of you for attending this very important webinar, and really a massive thank you to all of our panelists who gave such clear, powerful presentations, I think, on the real threat and urgent need for action that exists in this regard. Thank you so much. And with that, we've come to the end of our webinar. Thank you.